want next time, if you want next time to start a bit later, tell me so I can fix my schedule. Like if you want us to start like 10, 15 minutes later next Tuesday.
Next Tuesday. Maybe we can discuss by email, Prof, about the next
Yes.
Tuesday. Yeah.
Yeah,
Okay.
tell me what works best for the students. I didn't know they had the class right before. Sorry,
Yeah.
guys, for
Yeah.
that.
Pardon ya, Prof. Ya. So maybe I will start first ya, Prof.
Yeah.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, everyone. I hope everyone is doing well and remain in high spirit for our second guest lecture of intellectual property law with Prof. Nikolaos Voutyrakos today. My name is Sherry Yuswar, and I will be the host for this lecture. This guest lecture is brought to you by Faculty of Law Universitas Sumatera Utara. Today, Alhamdulillah, we will meet again virtually with our wonderful lecturer, Prof. Nikolaos Voutyrakos from Jindal Global Law School, India. I believe all participants and I will be benefited from insightful topic today about patent law masterclass, patentable and non-patentable subject matter and case study we discussed today. We will still have one class with Prof. Voutyrakos next Tuesday, May 28, talking about trademark law masterclass. So please don't miss it. So without any further ado, please welcome Prof. Voutyrakos. The screen is yours now, Prof.
Thank you, Cheryl. And hi, guys. Nice to see you again. So yeah, as already said, last week we covered the basics, but also some more advanced issues when it comes to copyright law. So today we will sort of continue the story, and I decided to continue this IP storytelling with patents because I feel that patents have some things in similar with copyright. So I think it only makes sense that we finish with trademarks because trademarks are a little bit a creature, on their own. So uh, I think today we will see how patents work compared to what we discussed last week, and how patents are a little bit different because we understand, even without even having started to discuss patents. With patents, we try to protect something that is closer to an idea. Something that we said last week, normally we don't do when it comes to IP. IP cannot protect an idea. An idea should belong to everyone, should be in the public domain. So what exactly do we protect with patents? This is something that we're going to see today. And in the last part of the lecture, I have again, as always, some case studies for you guys. And I have three case studies for you, but the common denominator in all three of them is the same. And it is, can we patent life? Can we have a patent over life forms? Be it human genes, be it animals, cloned animals, be it microorganisms. These are the things we'll discuss in the end after we make sure that we understand the theory, because really we have to address these issues legally, not our opinions, because with patents it's very easy to fall into the trap of addressing these issues ethically, which is a nice discussion to have, and we will do it to some extent, but we are lawyers. So obviously, after the ethical considerations, we have to address these issues as lawyers. So this is what we will try to do today. Now, when it comes to patents, one difficulty that we have, even though patents, I think, legally are probably the simplest form of IP. The law, when it comes to patents, is not that difficult. What is a little bit difficult in patents is that we're going to talk about some things that are a little bit scientific, are a little bit maybe technical at times. I will try to avoid technical discussions because you don't care about them. And also, there will be some terminology here and there, so you might be a little confused, but I will try to keep it as simple as possible. I'm sure Cheryl will help me at times if she thinks there will be a gap in the communication. But as was the case in the previous time, and as I always do, I made a handout for you guys, and I made it again in a Word format so you can keep your notes if you want directly there. And you will see the handout is slightly big, but because it's full of pictures and examples and all these kinds of things, So you can use this even after class, but I would say keep your notes there because the handout in itself will sometimes not be very understandable without the notes. So I'm sending the handout now. Let me know when it comes, because we'll follow the structure that I have in the handout to make sure that we're always on the same page. Just let me know when it comes to you.
Yes, we can download it, Prof.
Perfect. Okay. Okay, so as was the case in previous time, we will work our structure out based on the structure that I have in the handout. And the structure will be pretty similar as was the case in copyright. So what is it exactly that we protect here? What is the subject matter? Remember, in copyright, we said we protect expressions, and more specifically, we protect works. Works be literary works, artistic works, musical works, dramatic works. We also talked about films, sound recordings. These are the works that we protect in the context of copyright. And we discussed the idea expression dichotomy, and we said that we cannot protect ideas, abstract ideas, at least as such. The ideas have to be expressed in a more tangible way for them to deserve copyright protection. This is how we're going to start today's discussion as well. And even though when it comes to patents, the subject matter, I would say, is the largest part of the discussion when it comes to patent law. So something that was not so difficult in the context of copyright, in patents is the main discussion, because we're not even sure even today what exactly should we protect here and where should this protection stop. Because you will realize pretty quickly that patent protection is a very strong protection, is a very strong monopoly, is a very strong exclusive right that we give. In my opinion, much stronger than copyright. So we have to be very careful. How far should we extend this patent law protection? Now, to make sure we're all on the same page, a very brief introduction. I was planning it to be a little bit longer, but now in the interest of time, I think we can shorten it. I remind you guys, we're focusing on three main different rights here: copyright, patent, and trademarks. And we discuss them both commercially and legally. Even as a lawyer, you have to know these rights have a very strong commercial background, commercial underpinning that you have to be aware of. Now, all three of them have some differences, which is why we discussed them separately, but they share three characteristics that we discussed last time. First of all, they are exclusive. If you remember, we said last time what exclusive means. Very simply, exclusive means that me, if I have the copyright, if I have the patent, if I have the trademark, I can exclude everyone else from using it. Okay, exclusivity very simply means that I can exclude everyone else from using my right because it's mine. Only I can use it. I can allow someone else to use it, for example, by licensing, but in principle, it's only me that I can use this right. Okay, this is first. Second, we discussed that because of this exclusivity and because this monopoly that we give through intellectual property is so strong, you understand it cannot last forever. And even commercially, it cannot last forever because it only makes sense that because we give this type of protection to the right holder, for whatever reasons, and we discussed the justifications for copyright last time, we'll discuss them again when it comes to patents here. But because this monopoly is so strong, but we want to encourage people to create in copyright, people to invent in patents. We want to encourage these people to continue doing it, which is one of the main reasons that we give them this very strong exclusive right. Because we give them some protection, we give them some security to feel that, okay, I wrote my book, I made my invention. By having a patent over my invention, I feel secure that nobody's going to steal my invention and start selling it everywhere. So I have 10, 20, 30, whatever, how many years your legislation gives you, in order to do everything I want with my idea. Do I want to sell it? Do I want to license it? Do I want to do nothing with it? You can do everything you want. But because of that, the time of protection, the term of protection, as we called it last time, has to be limited. So in copyright, we said, usually the term of protection in most jurisdictions is 70 years, 70 years which start from the death of the author. So the moment the author dies, and we discussed how to find who the author is, and some like rules of thumb, this triggers the 70 years for copyright protection. Now, in patents, this is no longer the case. In patents, because of how strong this protection is and how closer we go to protecting the idea itself here, the protection must be much more limited. So the protection in patents in most jurisdictions will be 20 years. 20 years from when? From the time that you register your patent, which is a new term that we haven't discussed in copyright, because in copyright, you create something, copyright automatically exists. You don't have to register your work anywhere. You don't have to take your work, go to a copyright office, file it. You can do that in some jurisdictions, primarily in the US, but it's not a condition for you to enjoy copyright protection. So in all modern copyright jurisdictions, you don't have to file your copyright anywhere. You don't have to prove that you have copyright because you automatically have it the moment you create something. Now, with patents and with trademarks, this is not the case. In both the regimes, we have what we call registration. Registration, very simply, is a process where you go to the patent office of your country and you say, I have created this. You show them. Description. I have created, for example, this set of cameras on my phone. I want to file a patent for that. They tell you, this is a very good idea, but you know you have to specify it a little bit. How are the cameras arranged? How big are they? You have to be very specific in the registration, guys, otherwise it will not be accepted. Still, the protection has to be as specific as it gets. After you do all that, and by all that, I have again chosen something for you guys to see more practically. I send it in the chat now. This is from Canada, but it doesn't matter really. I'm trying to keep this, I told you, as jurisdiction neutral as possible. And what I send you is basically how you would go about it if you want to apply for a patent in your patent office. So if you open the link, you will see you want to apply for a patent for an electrical connector, let's say here. What do you do? 4 things, basically. You say, I want to file a patent for an electrical connector that does this, and this. Very briefly. Then, in the second stage, the description, you are a little bit more analytical. You say what exactly it does, because you want to distinguish it from whatever may exist already out there. Explain to the patent office how your patent is different. Otherwise, don't expect it to be accepted. Second one, after abstract, after description, you have something that is probably the most fundamental in any patent application. This is something that we call claims. What is a claim? A claim is basically, guys, what makes patents a little bit technical. And this is why most of these applications are filed only by patent attorneys, patent lawyers. Usually you wouldn't go to a normal lawyer to do these things because a normal lawyer wouldn't be very familiar to apply for a patent, because the language that we use in patents is very peculiar and individual to patents, which is why usually we go to patent attorneys and they do all these things for us. Now, at the end of the application, you will see usually, but not necessarily, but usually you include some pictures, some drawings as well. to explain to the patent office that, you know, whatever I described you in my description, in my claims, this is how I imagine it to work. And you will see at the end of the link that I sent, there are some pictures that you explain how do you imagine this to take place. So the reason that I focus a little bit here is that this procedure, guys, is essential to get patent protection. Patent protection is not automatic, as is the case in copyright. So keep this in mind, because this is the case with trademarks as well that we're going to see next week. Okay? Now, going back to the characteristic, we said exclusivity, we said limited time of protection. And the third characteristic to remind you is that IP rights, all of them, are territorial, are domestic concepts. And I told you, don't get confused if you see all these international agreements, all these Berne Convention we discussed last time for copyright, or Paris Convention for trademarks and patents, or the TRIPS agreement. The TRIPS agreement that talks about all of them is like the umbrella agreement. Don't get confused and think that this creates an international IP right, because it does not. The only things this convention do, especially TRIPS, that is the most important and the most recent that we have, is they create some minimum standards of protection. So that for me, if I am a Greek investor and I want to come to Indonesia to teach, or to create a company, let's say, to make it more commercial, how will I come to Indonesia to create a company, to invest, if I don't know that Indonesia has strong IP laws? Because if I make my company in Indonesia, Indonesia doesn't have a strong IP regime, and all my ideas get stolen within like 5 seconds, and you understand there's no motive for me to really come and invest there. Why would I do that? This is only a loss for me, and I don't want my ideas to get stolen. And even if I have a patent registered in Greece, this does not give me any protection in Indonesia, because IP is a territorial concept, is a domestic concept. Okay, guys? So what the TRIPS agreement will do is it will say to all the members that are signatories in TRIPS, and Greece and Indonesia both are, Indonesia has to secure to Greek investors treatment that is at least as favorable as it gives to its own investors, to Indonesian investors. So I cannot be discriminated against based on the fact that I'm a foreign national. This is what TRIPS will do. Give you some minimum standards of treatment, basically non-discrimination, in order to create a safe environment for me to come and invest. But that's the only thing these agreements will do. Okay? IP is still territorial. If I want protection for my IP right, for my patent, still I will have to go to Indonesia and apply the same way that you would do. Okay, guys? Otherwise, I will not get protected if my right is not registered there. So what sounds like a very bureaucratic and borderline stupid thing, this registration process, is very essential, guys, when it comes to both patents and trademarks. You have to register. Otherwise, even if you have made the best invention, the cleverest invention, nobody's going to protect you for it. Clear? Let me know if there is anything. And Cheryl, you can interrupt me anytime you think I make things complicated, but I think so far it should be okay.
Yeah, I think we can continue, Prof.
Perfect. So, let's try now, guys, to break down patents a little bit. But keep these generics in mind, because even from the generics, you can make some arguments here and there, legal arguments. But now we have to specify our discussion a little bit. So, when we talk about patents, we basically talk about two things. I'm simplifying a little bit here, but I think it's enough for us to trigger some discussion. You can basically patent either a product, or you can patent a process, a method for doing something. So you can either patent, let's say, for example, go to your handout and go to the second page of the handout. Generally, this handout is a little bit rich in pictures, but I think because it helps you know to understand a few things. So on page 2 of the handout, I have given some different examples of things that could be patented and things that are patented. For example, the first one is the mousetrap. Obviously, you understand the patent has expired. This is a very old patent, so now it's in the public domain. But you can patent the method of capturing a mouse. You can patent the method of dyeing hair. You can patent pharmaceuticals, drugs, product patent. You can patent, to call it more fancy, chemical compounds. For example, the moisturizer that I have in your last picture. So when you think about this huge umbrella of patents, think that usually you either go and patent a product, a good, or you go and patent a process, a method. Okay, these are the most common patents that we have. And in principle, you can go and patent both with the limitations we're going to see. Now, one difference that patent has that makes it a little bit more peculiar is that the whole logic behind patents is a little bit more negative. And by negative, I mean that basically having a patent gives you, the owner, the inventor, gives you the right to stop everyone else, to stop third parties from using your invention. So patent is a much more negative right. It's not like a copyright or trademarks that gives you a right to, commercialize and do everything you want, license your creation. You can do that, but this is not really a definitional condition when it comes to patent. Patent only gives you the right to stop everyone else from using your creation, your invention. Okay? Now, you understand that the fact you have to go to your patent office in your country and file for the patent means that essentially, if you think about it, who gives you the patent? Your government. Guys, it's as simple as that. It's a government branch that will sanction your patent. This means that here we have a little bit of state involvement with the good and the bad thing that this entails. Because yes, you have the government stamp, so it makes it very official. You didn't have this in copyright. The state was not involved in any way. But at the same time, you understand when you have the state involved, many things will go wrong. And what do I mean? When this whole conversation about patents and trademarks started and this registration and all that stuff, the governments were very happy to have these rights. Why? Because through patents, through trademarks, the moment you register them, it gives a perfect opportunity to the government to control the flow of information in the country. It is the best source of knowledge for the government to see what's happening in the country. And all that for free. You just have to go and give all this information to the government. So governments were, obviously very happy to accept, oh, let's have patents, let's have trademarks, let's encourage people to create more. Do they really did this for the creators, for the investors? Not really. They did it most because it was good for them. It's very good for the government to control the flow of information within their territory. So you go to your patent office. If the conditions are there, you will get your patent, usually for 20 years. You cannot renew it. So this 20 years is the end of it, usually, with a small asterisk that I will go to a little bit later. But in principle, bear in mind, 20 years and that's it. And in exchange of that, because you would think, yes, but why would I go and just disclose all my secrets to the government? Because essentially this is what you do. This very beautiful idea that you had, and now you have to disclose it. You have to reveal it for you to get the patent. Because to get the patent, you saw the link that I sent you. You have to explain how your idea works. And to explain how your idea works, you have to say all the clever things that you've thought. And you would think, but why then would I do that? What's in it for me then? Very simply, guys. In exchange for your patent, the owner, the investor, has to make some technical information publicly available. Otherwise, you will not get the patent. A question, though, still remains, and I would like you to be a little bit more involved here, if you would like, because this is similar to a conversation we did last week. Do you remember last week when we discussed the justifications for IP, which I told you again is a little bit heavy theoretically, but can very easily be a practical issue? Why do we protect IP? And we said all these theories, natural theories and all this reward theory, incentive theory. We talked about the tragedy of commons, all these things. Should we try to apply these theories in patents specifically? Because you will see some of them are not very convincing when it comes to patents because of the way that patents work that we are discussing so far. Who would like? Let's start with natural rights theories that I think are the simplest ones to get. And natural rights, I remind you, the Lockean theory and the Hegelian theory, the work theory, the labor theory, and the personality theory. The labor theory says, hey, I deserve protection merely because of the fact that I tried so much to create this. So Locke, the labor theory, tells you that, hey, this is enough for you to get protected. Hegel, on the other hand, says you have created something, the invention here in the patent case. So the mere fact that you have created this means that this is an extension of your persona, an extension of your personality. So this in itself justifies the protection of it. This in itself justifies the fact that you need an exclusive, strong IP right, which is patent in this case. This is what the natural theories tell you. The common logic between both of them is you understand, just by way of natural justice, I deserve protection over my ideas, either because I worked hard for it or because it's an extension of my persona. Now, when it comes to patents, do you think that these theories are working? Are they that compelling when it comes to patents? Can you think? And guys, please don't scare to not talk in perfect English, okay? Nobody's first language is English. This is not a language test. Just try to, just make sense. This is more than enough for me. But I want to see if you can combine these things. I see a hand. Yes, Zilmi, you want to help us?
Yes, actually, thank you in advance for coming to this session of lecture. But based on my opinion, I think, yes, the theory will work if the resource from the patent from its country, the origin country, has sufficient. Because as we know that if we learn from the case from the patent waiver during the COVID-19, I could see that the undeveloped country doesn't feel the impact of the patent waiver, because in the end, such as in Indonesia, because right now I'm searching and I'm studying about the patent waiver for the COVID-19 vaccine and its effect to Indonesia. And based on my study, that many theoretical that say the public health interest and the composition between the public interest and the patent distribution could be sufficient, but in fact it doesn't work in the field. I mean, so the best thing to do, if we have to increase the patent sufficient in each country, it will be the technology transfer. So I think the TRIPS waiver, the TRIPS could be a good umbrella act if between the developed country can make the working together with the developed with the at least developed country, undeveloped country. I think the transfer technology will be better. Let's be real, because not all the countries have the sufficient resources for the patent. And yes, indeed, the infestation from the other countries into another countries will be great, but it will increase more investment, especially in money, because if some countries that don't have any resources for the patent, so the only thing as the way out is the import. And yes, the import, it will be such as a threat for another country, especially for us in Indonesia, because it will be such as the middle income threat country that make our GPA will be decreased, and it makes us more adept for the contract itself. I guess that will be my opinion.
Okay. So thanks, Ilmi. Even though, let me disclaim to make sure that we're correct. When it comes to the natural rights theories that I asked, natural rights theories, you don't care so much about the societal output of the patent. Because the natural rights theories tell you need the patent as of right, just because you did something. The other group of justifications, yes, have a more social, print. But to respond to you, this is a general issue that we have with patents. Because what is patents? Patents is the purest manifestation of capitalism, as is IP in general, which is a little ironic that for me, that I'm not the biggest fan of capitalism. I specialized in the topic. But the thing here is that patent, we said already, gives a very strong monopoly. This monopoly, some people will end up abusing it. Because imagine in the field of drugs, in the field of pharmaceuticals that you say, in the field of vaccines, you have people having such a strong exclusive monopoly over a vaccine. This means that even if you have made the cleverest invention, you can very easily, for 20 years that your patent lasts, forbid everyone else from using it. Or, if you are more clever, you can overcharge. Because what will they do? They have to use your product. They cannot use anything else because for 20 years you can stop everyone else from using anything else. So either first way, you block all your competition, or second way, you overcharge because you have the monopoly, because people have no other option really than coming to you. This is, even though this is the case for patents for decades now, ever since we have this contemporary legal regime, COVID and the patent waiver and all that stuff triggered this discussion. Nonetheless, the outcome of this discussion actually, Zilmi, is much sadder than you would think. Because the main argument was that I spent so much resources to make this vaccine. This is why I need a patent for it. I'm not a charity. Yes, I understand the world is dying, but at the same time, if I give my patent for free to everyone, I will end up dying. Then why did I spend all these years and resources to come up with this vaccine? So that the developing countries would just come and steal it. Sadly, this is how the conversation turned out when it came to COVID. And sadly, this is one more reminder that the WTO doesn't work. It's not very easy to find compromises between developed and developing countries that have so diverging interests. This was the main problem here. Developed countries were like, why would we do that? Developing countries said, because, if we die, you will also die at some point. It's not that you can really isolate yourself from us. So, in Asia, still you found ways to do it, even in India, because I was here for part of COVID. After a point, they said, screw it, we will produce our own vaccine. We don't need you. In Africa, they couldn't do that because they don't have the resources to do it. Yes, but Africa is right next to Europe. It only makes sense that the more you stop them, in Europe, imagine I was in Greece, we kept having 1 million vaccines and dose after dose after dose, while in Africa, people couldn't even get the first one. But sadly, this is how patents work now. This is a monopoly that became so strong that now came back to us and is slapping us on the face. Let me take this discussion back to the justifications, because I want to have to theorize a little bit all these things, guys, because these things are legal arguments. I can make it sound logical for you, but I would rather you have them in mind as legal arguments. So, natural rights theory is the simplest one to grasp. Tells you you deserve the patent as of right, because you created it, because it's an expression of your personality, whatever, it doesn't matter now. Now, the reason that these theories are a little bit simplistic when it comes to patent is that actually this is the logic behind them in patents sometimes is not even true. Because remember, registration in patents. Registrations mean that the person that will get the patent is really the first person to file for it, to apply for it in the patent office. It doesn't matter if the first person had the same idea before, he won't get protected. It doesn't matter if a person had the same idea after without copying. Both people can think of the same thing. It doesn't matter, he will not get any protection because patent protects the first to file. Only this person will get protection. Yes, but even if a person thinks of the same thing after, shouldn't the natural theory justify protection for that? He worked so much to have this idea, he didn't steal it. No, patent protects only the first to file, which is a little bit weird in the light of natural rights theories. Now, continuing a little bit why I think these theories don't make much sense, then if you want to protect so much as of right the person, why do you only protect it for 20 years? Then you should protect it forever, if it's just an extension of their persona, if it's just the product of their labor and blah, blah, blah. This means that you yourself don't trust so much these theories. Because you say, after 20 years, that's it. Then it becomes public domain. Because then, this is why the government gave you the patent. To give you a motivation to use it however you want, but after 20 years, your idea should be part of the public domain. Everyone should have the right to use it. Then otherwise it would become a very strong monopoly that nobody wants for reasons that we already discussed. But because here, guys, we have companies into play, because sadly, patents are not in a state that you might think a crazy inventor closed inside a lab. This is not how patents work. Usually, patents now are owned by huge companies. The problem is that now companies become crafty. So what they do is, I create a patent today. I make an amazing invention, very clever. I directly go to the patent office in India, let's say that I am now, and I file for a patent. I get it. The fact that I got my patent today means that I will get protection for 20 years. We have 2024 now, so 2044, my patent would lapse. Very conveniently, 1-2 years before my patent lapses, I go to the patent office again, and I say, you know, I modified this a little bit, so now I have something new, so now I want another 20 years of protection. This is what most pharmaceutical companies try to do. They go and they say, see, I have created this pharmaceutical product, I have changed it a little bit now, basically it does the same thing, but it's not the same, it's something different, I improved it, so I want another patent now, and another, and another, and another. So they want to create a protection forever, but through the back door. Because as we said, normally you cannot do that. Patents is just 20 years and that's it. Yes, but after 19 years, if you go and say that you change the product a little bit, and you ask for another patent, should you get that? It sounds like something that is not fair. So this is a phenomenon that we call evergreening, patent evergreening. I wrote it in the chat for you guys. Patent evergreening very simply means a sneaky tactic of big corporates, usually pharmaceutical companies, that go right before the patent lapses, right before the patent expires, and say, I did minor changes, now I want another 20 years. This is something that the law didn't anticipate at the time, and this is why most domestic jurisdictions had to change the laws to keep in mind that we have to stop evergreening. Because evergreening, you understand, leads to perpetual renewal of patents, which is contrary to the logic that we are discussing so far. Now, to go back to similar things that we were discussing with Zilmi before. The second set of theories have a more social imprint. Reward theory, incentive theory, tragedy of commons. Reward theory, I remind you very simply, I want the patent as a reward. The society, we have the society at play now, the society owes me a reward because I created this beautiful product that after 20 years at the end of the day will become communal, will become public. So I want the patent as a reward. Does this sound convincing? One can say yes. And on the other hand, though, who tells me that the perfect reward for my invention is a patent? Is this a given that the perfect reward that I need is a patent? Why not money? Why not a salary? Why not an award? You know, why do I need a patent as a reward? Like, I can make it sound very logical, but it's not the only reward that you would be getting. On the contrary, it's a very strong reward for something you are making. At the same time, if you go to jurisdictions like the US, you will see in the US you can patent almost everything. And the problem with patents on life and all these things that we'll discuss in the end started in the US because the US started giving patents over human genes. Imagine the level that we are. You isolate DNA and you take a patent over it. This has created huge issues, even though in the US this was standard practice until the case that we'll discuss now, which is pretty recent. But it was standard practice. Scientists went in a lab, they isolated part of the DNA. They said, now this is not a DNA anymore. I isolated it, so I want a patent over it. This is the level of insanity that we have reached in the field of patents, guys. And this is why I wanted us to focus there in the field of subject matter, because for me, the most important thing here is we have to agree what exactly are we protecting here and where should this protection stop? Because against thinking the more like utilitarian arguments, utilitarian theories, logic, do really patents create social welfare? Do they promote social welfare? With Zilmi, before we discussed many times, they do the exact opposite. They create so strong monopolies that really exclude everyone from using these products. I create a drug, I create a pharmaceutical product which cures cancer. Immediately, I go file for a patent. And I sell my product for $5,000 per pill. Because why not? I charge it however much I want. This is how capitalism works. Yes, but at the same time, if I sell this in India, very few people will be able to afford that and give $5,000 per month in order to eat this pill and get treated from their cancer. So this is why I want you to have in mind that yes, having a patent sounds very fair, but it can be manipulated very easily, guys. Yes, it's a good reward. Yes, it's a good incentive to create more and more and more because you have this 20-year security that nobody will steal your idea because it's protected by the law. Yes, you have an incentive to even sell your idea, bring investors to invest in your idea. Because if I have 20 years of protection for my cancer drug, for my cancer pill, I know that in these 20 years I can go to investors, and these investors will be much more likely to invest in my idea if they know that this idea is protected for 20 years. Because investors are not stupid. They're not going to invest in something that I will not have protection over in a few years. You understand that? So patent is a good incentive for me to keep creating, is a good incentive for me to develop my idea even more, to make it better and better and better in these 20 years. And it's a good investment for me to disclose my idea to potential investors. Okay? But at the same time, patents are not saints. There are many things that are not working well with patents, and I think COVID was a very sobering reminder of how unworkable patents will be if abused. Now, If you go to your handouts on page 3, I want you to see another picture that I have for you, which is actually a tweet. It's a tweet by Elon Musk for many years ago, before Elon Musk became the owner of Twitter. So, in not very good English, but he was trying to make a joke, Elon Musk said, all the patents we have from Tesla, you know Tesla, the electric cars, now become public. You can copy me. I'm not going to sue anyone for copying my patents. And he said, all our patents are belong to you. On top, he says, I quote, competitors that are going to make more electric cars, we want to promote this actually. What we want to stop is the bad gasoline cars, the bad petroleum cars. Now, what do you think of this open access, patent logic of Elon Musk? Good, bad, workable? Why do you think he did that? Is he really such a good person? Because he doesn't have that reputation. Why would he do that? Can you think, based on all this theory that we have discussed so far? I think, guys, this is not difficult. If you cannot think, I'll give you some scenarios.
Is it about fair use, Prof?
Sorry?
About fair use? No.
No, because in patents, we don't have a fair use defense in the sense that we have in copyright. Generally, the defenses in patents, which is why we're not going to focus so much on them, are very, very limited and are usually focused on pharmaceutical products, which you understand raise the most issues here. But you don't have an all-inclusive umbrella defense of fair use like you have in copyright. Here, defenses are very, very limited. So why would you do, if you were Elon Musk, why would you make your patents after you have spent so much time and so much money to file for these patents? Because these patents exist for Tesla. He just realized after a point that he wants to make them public so that everyone can still use these patents and create more electric cars. Let me tell you what I think, guys, even though mine is not the most possible interpretation, but because I don't trust these people, I'll tell you why I think he did it. Back in the day, this tweet was like 6-7 years ago, but not that the situation has changed much today. But back in the day, like 2018 that we have this tweet, the market for electric cars was very small. So he thought, if I make my technology public and everyone can produce more electric cars, so everyone, I mean more mainstream companies like, Suzuki, Toyota, Nissan, if more mainstream automobile companies produce electric cars, does this really harm me? Mine is no, because now you have the electric cars market that is very isolated in some more niche places. Do I see any electric cars in India? No. Is it because Indians don't have money? No, there are many Indians that have insane amount of money. Why wouldn't they get electric cars then? They're supposedly the best ones and the more self-sufficient, you don't harm the environment. There isn't anything bad to it other than the fact they're so expensive. At the same time, in India, you will find no charging spots for electric cars. In India, you will find no technician that knows how to repair an electric car. Yes, but if all the mainstream companies start to create electric cars, there will start the need to create infrastructure to charge your car, to create infrastructure for someone to repair your car. So if I make, as Tesla, if I make my patents public, gradually there will be more cars, electric cars. If there are more electric cars, there will be more people able to service these cars. or there will be more charging spots for these cars. So what seems like a charitable act that I'm doing, basically I'm doing to help myself, to bring Teslas to India. But if only Tesla exists that makes electric cars, there's not enough motive for people to create all these things that are necessary for electric cars. And to give you some funny, like anecdotal, similar story, back in the 50s, you have Volvo. Volvo is, another car company. Volvo was the first car that created this 3-level belt. Back in the day, the belt was just like that on your waist, and this is what you had in your car. A little bit dangerous. Volvo came up with the idea that you need this one. So you have a protection on your waist and the protection from your shoulder to the waist. This made cars very safe. Immediately, Volvo went and filed the patent. After a point, it thought, maybe isn't it better that I waive my right over my patent and help the people so that other companies can copy my model of seat belts, which is now used by all the cars in the world. It's mandatory. So Volvo said, actually, I waive my right to my patent. Feel free, everyone should use it. And now Volvo stayed in history as the company that made the safer seatbelts available to the market. So, yes, it can be an act of good faith and really you want to save lives or the environment in Elon Musk's case. But at the same time, it can be a nice marketing strategy because you really want more infrastructure for your own cars. So your competitors producing electric cars is just a necessary evil to attain this objective. Clear? Okay, let me know if there is any question. I can come back to that. But have this justification in mind, more the natural theories one, the utilitarian ones, good things, bad things when it comes to patents. I would like you to be comfortable with these theories because they're not so heavy as they may sound if you have understood how to apply them. Now, let's move to the more law part that luckily in patents is not so difficult. In any kind of patent exercise, you have to basically do 4 things. You have to prove 4 things. And this is again in your handout. If you move to page 4, I have made this very beautiful pyramid. Excuse me. In this pyramid, we will start from the lowest level and going back to the top. So the thing that we are going to focus more is the thing at the bottom, which means that what exactly can we patent? What can be a patentable subject matter? And where does this protection stop? And can we really patent life? And the 3 conditions that every patent law in the world virtually will require is that your patent must be novel, novel meaning new, must be involving inventive step, and must be susceptible of industrial application. Now, we have a little bit of terminology here, but I told you, in my opinion, the law here is very straightforward. So let's take them one by one and tell you briefly, without making this complex, what they mean. First of all, subject matter. I will say very few things because I will focus on it during the case study discussion. But what are we protecting here? Inventions. What are inventions? I have taken the passage from TRIPS agreement that tries to address, what exactly an invention is in order for it to be protected. I quote, patents shall be available for any inventions, whether products or processes, we discussed that already, in all fields of technology, provided they are new, novelty, involve an inventive step, and are capable of industrial application. These 3 things is what we need. Patents shall be available and patent rights enjoyable without discrimination as to the place of invention, the field of technology, and whether products are imported or locally produced. So, 3 criteria for patent protection and non-discrimination, which I told you already is the main logic behind international conventions. Now, without knowing Indonesian patent law, I have a very strong feeling of how it's going to be And probably it will not really tell you what is an invention, how is an invention protected. It will usually tell you what is not protected, what is not patentable, what subject matter cannot get a patent. This is how most domestic legislations are addressing this matter. And if you continue in your handout, I have put together like a collage of most things that normally you cannot have a patent on. So you cannot have a patent on things that are contrary to public policy, to morality. You cannot have a patent over a discovery, a scientific principle, a mathematical equation. These things you cannot get patent. Or what we discussed before, evergreening, you cannot have a patent over mere discovery of a known substance without enhancing its efficacy. Or you cannot have a patent over methods of agriculture. You know, the logic is similar in all of them. You cannot have a method over things that should belong to everyone. These things, no matter how your idea was, especially because your idea is so good sometimes, this is for everyone. This is not just for you. Okay? And very importantly, and much closer to our theme for today, you cannot have a patent over plants. You cannot have a patent over animals as a whole, not including microorganisms. You cannot patent mathematical methods, business methods, algorithms. This would be strong of a patent to give you, so we're not giving it to you. You cannot patent literary, dramatic, musical, artistic works for the biggest reason being that we have copyright for this. It's very important that we keep these rights isolated. And yes, you may have cases where copyright and patents are a little bit overlapping, which makes it very interesting from a lawyer's perspective. For example, computer programs. Computer programs usually will have both a couple of patents inside them and copyright. A computer program is a literary work. It doesn't sound like it, but this is how we protect computer programs as literary works. So you get things that usually we exclude. It doesn't matter for me to make you a whole catalog, even though you can see this in the handout. But it all boils down to what your domestic legislation will say. So if you want to see what is non-patentable in Indonesia, because I told you, you will not see what is actually patentable, you have to go to your domestic patent law. Which, by the way, I did my research a little bit on Indonesian law, because patent law, because I didn't want to sound like very ignorant. And I will come back to that in a little bit when we talk about licensing and compulsory licensing, because this is a very common, apparently, in Indonesia, even in India, but in Indonesia, apparently, it is more common. So I want to spend a little bit of time on it. Now, the three criteria you have here, very simple to remember, guys. Novelty. Novelty very simply means your invention has to be new. When is an invention new? New is when the public could not have anticipated your invention, anticipated based on what already exists out there. Now, what I try to explain very simply, in most of the laws, has a little bit difficult language. So in the law, you will read something like, novelty means any invention which has not been anticipated by the person skilled in the art. Remember this person skilled in the art. It's very important in any kind of patent exercise. And this person should not have anticipated your invention compared to the state of the art. What are all these confusing things? What is the state of the art, first of all? State of the art, guys, is everything that exists until you made your invention. So state of the art means whatever is there before you made the invention. So this person skilled in the art will consider all this information, all this knowledge that exists out there, and will think, can I use this knowledge to create this invention that you came up with? If I can, it's not patent worthy because it's not novel. If I cannot, then it's novel. then maybe you deserve a patent. If it's also inventive and if it's also susceptible of industrial application. Okay? So first criterion, novelty. Who decides on novelty? The person skilled in the art. And when does he do that? Taking into account everything that existed or the state of the art that existed before you made your invention. Okay? Second step. If it is novel, we proceed with the equation. If it's not novel, we understand, we stop. Then there is no patent anymore. Second, inventive step. What is inventive step? Very easily, non-obviousness. Inventive step means that your invention has to be not obvious. To whom? Again, the person skilled in the art. Guys, you have to love the person skilled in the art because you use it twice in both the exercise, both in novelty and in inventive step. You need to address this from the perspective, from the shoes, from the position of the person skilled in the art. Now, what is the art every time? It depends on what field you are. Are you in technology? You want the person skilled in the art of technology. How skilled? The courts will tell you a little bit skilled. Like he has some skill, but he's not very imaginative. He can only combine information which are out there. He cannot be more crafty than that. He's the average person. We'll see next week in trademarks. We also have notional marks. We'll call him the other person skilled in the art. Now, if you go to page 7 in your handout, I have tried also to put a picture of the person skilled in the art, but I think I made him look a little bit stupid. But this is how courts look the person skilled in the art. Yes, he is a person that comes from this market, from this industry that we are assessing. He has some general knowledge. He has an interest in this subject matter we are assessing. He is reasonably intelligent, but lacks imagination. Okay? This is your notional figure. This is how to conduct the patent exercise, both for novelty and for inventive step. And I told you novelty is new, inventive step is non-obvious. Last step and the easiest one, your idea, your invention has to be capable of industrial application. It has to be useful, basically. It means that the invention is capable of being used in an industry. What industry? Depends on your invention. Again, it all boils down to whatever domain your invention is applicable in. But this is the least problematic one and never causes issues in practice. But to remember the whole story, yes, you have to prove your subject matter is patentable. Or most of the times, you have to prove that it is not patentable. Because the law will define it in a negative way. We show how. Then you have to prove it's new. You have to prove it's inventive, non-obvious, and you have to prove it's capable of industrial application. This is the exercise you will do in any kind of patent, in any kind of jurisdiction. Okay, no matter where you go, you have to have these things in mind. And how do you assess novelty? How you assess inventive step? In the handout, I have put more things to help you, but this is if you want to take it a little further. Okay. When it comes to the basics for a patent exercise, I think this is enough for you to have in mind. But for those of you that want to take it further, read my handout after class. Okay. Now, let's say we have done all this and we have proven all this and we took the patent. Another question that we also discussed a little bit in copyright, but in copyright it wasn't really problematic, is who owns the patent? Who is the owner? Because only the owner can sue for infringement. So it's extremely important to know who is the owner of the patent. In copyright, if you remember, we said the first author, in principle, is considered to be the owner. Now, in patents, you will tell me the inventor, most probably, which is true. In principle, again, the inventor is the owner of the patent, and the inventor can sue for infringement of the patent by anyone else. A small caveat, though, which we also discussed in copyright, when it comes to the cases of employment. Remember in copyright that we discussed what happens if the employee creates the work. And we said usually the employer will take the credit for it. The employer will have the copyright. And we made the distinction between contract for service, contract of service, independent contractors, and the difference, for example, between Cheryl, who is an employee in the university, and me, that I'm not an employee, I'm an independent contractor, that I have a contract with your university to provide some services, it doesn't matter. So if I make a creation in the context of my work here as an independent contractor, I will have the copyright over it because I'm not an employee. I don't have this relationship of subordination that you need for an employment relationship. Cheryl has it though, so Cheryl has to be very careful if she makes a creation or if she invents something in the context of her job. Okay? Same is the logic in patents as well. So bear in mind, if you haven't clarified this with your employer in your employment contract, you might lose the copyright, you might lose the patent over your creation or over your invention. So be very careful with that in the context of employment, because this is an issue that you can resolve. You can resolve contractually, but you need to be clever to do that at the time you're negotiating your contract. Otherwise, the position of the law is that in principle, the employer will enjoy either the copyright or the patent. Now, continuing this, what exactly can this owner, let's say we have found the owner, what exactly can this owner do with the patent? Two things, basically. Either he can assign it, assignment very simply means sell it, or he can license it. Licensing means very simply rent. So you can either sell or rent your patent. In the context of that, because this is the case for any IP right, assignment and licensing you can do with any IP right. The logic is the same. What this makes it a little bit more peculiar in terms of patents, and what I was reading yesterday when I was looking for Indonesian patent laws, are you aware of the concept of compulsory licensing? Very nice. Guys, let me tell you. What happened here? We said a main problem we have with patents is that it's a very strong monopoly. When you bring this problem into the pharmaceutical sector, the pharmaceutical domain, you have companies that have created a very useful drug, a very useful pharmaceutical product, or a very useful pharmaceutical process, but they block everyone from using it by making it extremely expensive. You understand that in developing countries, this causes many issues. And this has caused many issues in India. It has caused even more issues in Indonesia. So how have governments addressed this issue? Through this mechanism that we call compulsory licensing. What does this mean? You have a huge pharmaceutical company, let's say Novartis or Bayer, or the classic like huge pharmaceuticals. Novartis comes to Indonesia, has invented like a huge, amazing patent to cure cancer, files a patent for it, because why wouldn't it? It fulfills all the requirements that we discussed. So after that, after it has the patents, it makes it so expensive that basically nobody in Indonesia can afford it anymore. And after that, people say that this is not possible. Not only can we not buy this product, but nobody else can also make it because of the patent that Novartis has. So it's a very offensive way of using your patents against the competitors. So how compulsory licensing tries to find a solution there is that the government steps in and says that this is not working for me because you're blocking my people by setting so unaffordable prices for them. Like, know your audience. You're not in Switzerland, you're in India, you are in Indonesia. You have to make sure that people can afford this product. So what we're going to do is we're going to create a license for your product, which is still yours. You have a patent for it, and give it to an Indonesian company. Then the Indonesian company is going to make a copycat product through, reverse engineering or through, whatever method, the same product basically, and is going to market it in the Indonesian market, obviously in a fraction of the price, maybe like 5 times cheaper, so that people can afford it. Is this something that we should allow? Because this is standard practice now, by the way. Not so very difficult to give, but happens. In India, a few times has happened, in Indonesia more. Is this something that is so fair as I make it sound? Because I make it sound as if it's a charitable act from the government to help its own people and things like that, and make the otherwise unaffordable products affordable for them. And nonetheless, then, why do I have the patent as Novartis in the first place? Why did I spend all this money and all these resources, maybe 10 years of research, to make this cancer drug in the first place? You know, is this incentive theory that we discussed before? Is the justifications that really create legal arguments after a point? What's in it for me? What is my incentive then to create? If the Indonesian government will just give to a random Indonesian pharmaceutical the right to use my product, then where do I stand exactly in the Indonesian market? Because it seems like I stand nowhere. You know, this creates other issues as well. But the current state of the law is that the government can intervene and move with the compulsory licensing in case the product is completely unaffordable and the company makes no effort to make it affordable for the people. So have this thing in mind, because, okay, obviously patents are most controversial when it comes to these things. You understand that. This is the elephant in the room. So have this in mind in case you end up working with patents in Indonesia, or you end up like in-house in a pharmaceutical, because it's likely that one way or the other, either you will have to support compulsory licensing or fight against it. So you have to know a little bit both ways of doing so. Now, in the final part of the class, I want you to talk a little bit about our case studies, which you will find in the final page of the handout, page 9. Now, I have 3 case studies for you, all of them from the US, because I told you insane things are happening in patents there. And I would like us to see, where do we draw the line? I have named this Patents on Life, which is just like a catchy title that I could think, but it's not far from the truth. This is what people started doing. And even though we read before when we discussed that you cannot patent plants, you cannot patent animals, you know, you cannot patent DNA because it's already there, it's nature, you cannot patent nature. How did people do it then? How did it become a norm in the US? See the first case, 1980. This is the case that started everything, guys. And then they started giving patents on life forms like peanuts. So, 3 cases that talk about similar things from a different perspectives. First one, Diamond versus Chakrabarty. In Diamond, what happened basically is you have this person here, Chakrabarty, and what he does is he wanted to find a method to clean the oil, the petrol, from the sea. Okay. Now, after years of research, he realized that there are some bacteria that can go to the sea and eat the oil. Nonetheless, for this bacteria to get triggered and not immediately die from the petrol, from the oil in the sea, he needed to make some changes in this bacteria. So he came up with a bacterium that was genetically modified, genetically engineered. He makes this. He tries it in the seas in the US. It works. So very happy, he goes immediately and files for a patent. And he files for a patent for different things. The 2 most important being, first of all, the method of engineering the bacterium, and second, the engineered bacterium itself. Now, the method is not so controversial. It's obvious that he would get a patent over the method of making the bacterium. But could he get a patent over the microorganism itself, which was the second claim? This created a huge controversy. This case went all the way to the Supreme Court of the US, as did another case that we'll discuss in the end. So the Supreme Court had to decide, but isn't this like giving a patent over a life form? The issue is that yes, it is. Nonetheless, The court said, yes, but here it's not really that she took the bacterium and used it and asked for her to have a patent over something that just exists in nature. She genetically modified it, she put her own touch into it. So now, is it really a form of life anymore? No, said the court, it's a genetically modified microorganism. For that, in our opinion, we should have a patent. And these guys started a floodgate, like, the Pandora's box of life patents, because then everyone started applying and saying, oh, yes, I have the DNA, I isolated a part of it, I worked a little bit for that. I want a patent on that. Yes, but that is in my body, Is it normal just because you isolated it? Yes, you can get a patent on the method of isolating it, but not on the DNA itself. This sounds like too much. We try to put a limit with the next case. The next case is the dolly sheep. You must have heard. It's the first cloned animal that we have. So what this person did is he took, like, the process is there in your handout, but it's a little bit complicated. So very simply, listen to me. What this scientist did is he took some cells, some nucleus cells that were dormant, that were sleeping from the original cow, from the original sheep, the alive one, and they reproduced them in a tube, in a lab. And by that, they created an embryo that was alive, like artificially alive, and a clone of the original. He goes again to the patent of the US and says, I want a patent over the method for cloning, and I want a patent over the clone itself. Same logic as in the Diamond Chakrabarty case. The court said, yes, you can patent the method of cloning. Yes, amazing idea. But how we can give you protection over the clone? This is like, first of all, giving you protection over life, giving you patent over life. This is something that even in Diamond Chakrabarty, we said there are some limits. Like, where is exactly your contribution? The scientist says, everything here is my contribution. But for my intervention, there would be no clone. So what do you mean? So the court realized that this argument will not work in this case, because really the intervention here is 100%. So how the court ended up rejecting the patent over Dolly the sheep is by saying, yes, now that I think of it, actually the reason that I'm not going to give you a patent is because this is not original. This is a copy of the mother sheep. In the mother sheep, I would have never given you a patent. So how can I give you a patent over something that is the exact replica of this? So using this argument that I don't know personally, I don't find that convincing, but logically, like legally it makes sense, but logically I don't buy it, to be honest. Because yes, that's the whole purpose of the clone. This means that you cannot have a patent over any clone because it's an exact replica of the original. I don't know, for me this is not enough, because we have discussed the law so far. The law doesn't seem to forbid it. But in that logic, no patent here. And guys, let me now take you to the craziest case of them all, in my opinion. Patents over human genes. Patents over things in your body. Because you say, okay, one case is about microorganisms, the other case is about Dolly the sheep, a cloned animal. Yes, you may not care about this, and you may say, okay, then why do I care for these patents? Let's give it to them. Because it will come back and bite you if you do that. And this is what happened in the third case. So there is a company that is named Myriad Genetics. Myriad Genetics, what it did is basically, if you go to the final picture in your handout, it found these two isolated forms of DNA. These are called BRCA1, BRCA2. You can see them in your handout. What was the issue here? Now, these two genomes, I mean isolated DNA forms were very useful because if a woman had mutations of these isolated DNAs in her body, it meant that this woman was very likely to develop some kind of cancer, ovarian cancer or breast cancer. So it was very important for scientists to isolate these DNAs, check, does the woman have them? If she does, it's very likely this woman will get cancer. So Myriad Genetics invented a method to isolate this DNA, and you know now how usually it goes. It goes for a patent, both for the method of isolating the DNA and for the BRCA, BRCA1, BRCA2 themselves. Gets the patent. Because it's standard practice, we said in the US, after a point, these patents were given like peanuts. Nonetheless, what happened in practice? After getting the patent and the monopoly over these human genes, Myriad Genetics made the test extremely expensive, one issue. But not enough of an issue in the US, but one primary issue. Second issue, Myriad Genetics stopped updating their tests to find, if the woman will likely get cancer because of having these mutations. It stopped updating their test based on the technology that was available after their patent. Because they said, why do we care? We have the patent now, we have the monopoly, why should we improve our technology? So even though there was research that improved this issue after that, they didn't include it as part of their tests. This meant that, guys, after a point, there was some level of inaccuracy in these tests, and there were some level of false negatives. People that were positive, the test that, by the way, costed $3,000, told them they were negative. And there was a woman in the US that had this test. The test told her you're negative, you have nothing to worry about. It was one of these wrong negatives. After 2 years, she dies. Because the test was not updated and was not good enough and gave her a false negative. And so after a point, many human rights organizations said that this cannot continue any longer. We have to stop patents on humans because it creates issues, as was the case in Myriad Genetics. They challenge it, goes to the court, goes all the way to the Supreme Court, and very rare for Supreme Court to listen to IP issues. Very rare for cases to go all the way to the Supreme Court. And the Supreme Court had to decide, because it sounds right, we cannot give patents over human genes, but at the same time, this would overrule a 25-year practice of the US. And it did, guys. For the first time, the US Supreme Court said, you are not going to get a patent from now on human genes. This patent is no longer. Because yes, you isolated the DNA, but what is DNA? A judge said, DNA, the isolated DNA is just nature sitting there. You cannot have protection over just nature that is sitting there. Yes, you can have a patent over the method that you invented to isolate this DNA, but it's impossible for me to give you protection over the BRCA1, BRCA2 genomes themselves. This is like extracting gold from a mountain. Even if you extract the gold, it is still gold. You cannot get a patent over it. This was the logic of the court, and imagine how simple I can make it sound for you. But this overrules a 25-year practice of the US patent to give these patents like crazy for all these years. And it was Myriad Genetics that stopped this trajectory, unfortunate trajectory of giving these patents. So, a very useful case, in my opinion, for you to have. If you want to see, I have a hyperlink. If you click on this case, it will refer you to YouTube. It's a TEDx talk, and I know you might be skeptical. Why would I send you a TEDx talk? But it addresses this issue. It's like a 15-minute video. Go and check it out after that. It talks about all these things that I told you. It talks a lot about what happened in the High Court and in the Appellate Court as well. It gives you a little bit of story. Not from a lawyer, though, so don't expect crazy legal stuff, but expect very nice storytelling. So if you're interested in this case and how it happened and what was the case before in the US, go and check it out after our class. But that's it from me.
Okay, thank you, Prof, for such informative presentation. So, class, we have already listened the presentation from Prof. Nikolaos. If you wanna, so we will go to the Q&A session, yeah. And if you wanna ask question, you can raise your hand and ask directly to Prof. Nikolaos.
Yes, guys,
anyone?
even after, by the way, you can always reach out to me. I saw a couple of you added me already on LinkedIn.
I think we have Linda Ariska, Prof. Yeah, Linda, you can ask
Yes, Linda,
directly.
yes. Linda was one of them.
Thank you so much, good afternoon, everybody. I have a question to Prof. Nikolaos. If an employee of the company develops an invention or discovers the new product or something else, so who has the right to the patent? An employee or the company? Thank you, Prof.
Linda, the same is the case as with copyright. Generally, IP ownership is pretty standard, no matter the IP right that you have at stake. The only difference here is when it comes to compulsory licensing and all that stuff that are peculiar to patents. But in general, if the employee makes the invention, in principle, it will go to the employer. This is what your patent law will tell you. How you can avoid that? If before, when you make your employment contract, when your employer hires you, if you include a clause in the contract saying that whatever I produce, whatever I invent, whatever I create, because you want to, include copyright as well, not only patents, because it's more likely you will have something copyrighted than something patentable. And whatever I produce in the context of my employment, the IP will vest with me. If you don't say that in your contract, it will go to your employer, the patent, over what you produced. This is what the IP law will say. If you want to prevent that from happening, you have to resolve it contractually when you draft your employment contract. If you don't, then you have lost the game of ownership. Okay?
Thank you, Prof.
Okay, Linda, yeah, Prof, allow me to maybe explain a little bit to Linda ya about your answer. Jadi gini Linda, jadi tadi itu pertanyaan kamu, kalau jawaban Prof itu berdasarkan kontraktual agreementnya. Tapi umumnya kalau ngomong IP biasanya itu pemilik pertamanya pasti kita yang menemukan. Kecuali ditentukan lain di kontraknya bahwa dalam hal misalnya Linda bekerja nih, Linda bekerja apapun hasil pekerjaan Linda di perusahaan itu maka akan menjadi milik perusahaan, ditentukan begitu baru dia. Jadi dia lebih berdasarkan kontraktual Linda itu penentuannya. Kalau apakah ketika kita menemukan sesuatu itu menemukan paten apakah menjadi milik perusahaan atau milik kita itu kita lihat kontraknya gimana, apakah memang bakal otomatis jadi milik perusahaan atau diizinkan jadi punya kita. Itu sih Linda tadi kata Profnya. Oke. Thank you Linda. Is there anyone else wanna ask to Prof Nikolaos?
Izin Bu.
Yeah, Samuel. We have Samuel, Prof. You can ask directly.
Okay. Terima kasih Bu. Thank you Prof. I just sorry for the noisy one. I just want to ask if a company like a broad company like AstraZeneca merger with like Indonesian pharmacy company like Kimia Pharma or maybe you can name it. Is the patent from the Kimia Pharma or the Indonesian pharmacy company, and if this company merger with another company and becoming a new company again, if the new company have to register again the patent, or is it just it?
Okay. Yes, this you're right. We didn't cover, even though last week, when we discussed about IP in general and what is IP, we were discussing what is property and what is intellectual. All these things answer your questions. So a patent is nothing more than property of the company. If the company merges with another company, the patent stays with it. If there is a new company, the only thing you go to the patent office, you change the name of the owner because the name of the company has changed, most probably after a merger. But that's it. Other than that, do you not want the patent anymore? You sell it. You give a license. You do anything you want with it. The patent is like you have a house. Don't think of it as if it's something very different. It's just like a good that you have. A good that you cannot see because it's intangible, but it's your property. Don't see it as any different. It's like you have your phone and you sell it. Okay?
Okay, thank you, Prof. Kasih, Bu.
Oh, thank you, Samuel. Is there anyone else? Want to ask to Prof. Nikolaos? No. Okay. I think that's the end session for the Q&A, Prof. And for the participant, please open your camera because we will take a group photo shoot. Please open your camera. Okay. And give your best smile. Okay.
I feel like I
Yes,
exhaust them every Tuesday. I feel like I exhaust the students.
Okay. Please open your camera, class. Okay. Okay, 1, 2, 3. The second, okay, 1, 2, 3. Okay. Prof. Nikolaos, thank you for the session today for the patent law masterclass. We will meet next week on Tuesday.
Yes.
Yeah,
Yes.
Prof?
And Cheryl, text me
Yeah.
if you would like us to start a little later. I can do that. But text me in advance, okay?
Okay,
Perfect.
sure, Prof. Yeah. Sorry ya, Prof ya. Yeah. Thank you for today. Have a good
Thank
day.
you, guys.
Bye-bye.
Great to
Assalamualaikum
see you. Next
warahmatullahi
week,
wabarakatuh.
trademarks.
Ya.
See
Ya.
you.
Makasih ya semua.